Good afternoon. Everybody wake up. There we go. Good afternoon, everybody. It's 1:30, and I want to get started. All right. I'm Judge Schiff. This is the afternoon docket, Magistrate Court. When I call your name, I'll ask you to come up. A couple of things I want you to understand. Today's not a trial. You have the presumption of innocence throughout the entire process. The purpose of today's hearing is for the court to determine whether or not there's probable cause to believe that you may have committed an offense. If I find that there's probable cause to believe that you may have committed offense, then we'll get to the next issue on what a proper bond should be in order to secure that you'll come back to court. The state is here, you have a defense here, and everybody will have an opportunity to be heard. If you are going to speak to me, you might think about it first, because anything you say could be used against you at a later date. But I'll give you that option. I'm not going to tell you that you can't speak. If you do speak, I'd ask you to be respectful. So first person is Jennifer Scarborough, please.
She's in North Broward, Your Honor.
Thank you so much. Good afternoon, Ms. Scarborough.
Go ahead, Your Honor.
Good morning, or good afternoon, Ms. Scarborough. The court's reviewed the probable cause affidavit, and after review of the probable cause affidavit, finds probable cause, count 1, possession of heroin, $1,000. Count 2, drug paraphernalia, that's ROR, and count 3 is a pedestrian violation, which is not for magistrate, and I wish you well.
Your Honor, I spoke with a friend of Ms. Scarborough's,
Yes.
and he indicated to me that he is going to bond her out.
Okay, very good.
All right, good luck, Jennifer.
I wish you well. I wish you well.
Thank you.
Jalissa Samuel. And we're,
Samuel is here, present, Judge Maine.
thank you. Count 1, no probable cause, state has 24 hours. Count 2, probable cause, ROR. Thank you.
Judge, in reference to count 1, I know right now it's the standard bond is $1,000. Unfortunately, speaking with Ms. Samuel, she's 23 years old. She's currently unemployed, looking for work. She said basically her past contacts with the criminal justice system were misdemeanors. She grew up down here. She went to Hallandale High School. Her uncle's the only person that could post her bond, but her uncle's on disability. Is there any way you would consider pretrial release for Ms. Samuel if pretrial can verify her address?
Pre-trial, before I get to the state?
Your Honor, she told us that she had no stable residence at this time.
Thank you.
No numbers or anyone for us to contact.
Thank you.
And I was just gonna say, I don't believe she can go on pretrial unless there's.
Until you, I understand. I just wanted to hear, and then now I found out she doesn't even have an address, which is contrary to what she's telling us now. So the state has, here's the good news. If the state doesn't come up with something in 24 hours, I'm gonna RO, I'll be back tomorrow. In the meantime, if she can get somebody to bond her out, she can get somebody to bond her out, okay?
In the meantime, Judge, could the pretrial verify and talk to her uncle and see if they could verify that address? Her uncle says that she could live with her.
Well, first of all, she's given her, let me just see if I understand this correctly. The information that she's given you, counsel, is different than the information she gave to pretrial release. Don't say anything, ma'am, please, okay? Now, tomorrow, when they're going through the jail again and they're talking to people, and if she's there and they can talk to her, that's fine. But to ask them now to start doing something that's contrary to what she's already said, no, the answer is no for today. Thank you very much. Corey McCabe, please. He bonded, thank you.
Bonded.
Calvin Cross, please.
Mr. Cross is here, present, Judge.
Thank you, Mr. Cross. The court has reviewed the probable cause affidavit, and the court finds one count of battery on a person 65 years of age or older. I'll hear from the state, and then I'll hear from the defense.
As far as criminal history, he has a 2008 2 counts of resisting without violence, 2008 misdemeanor possession of cannabis. Your Honor, based on the age of the alleged victim, the state's going to be requesting a $5,000 bond and no victim contact.
Okay, and response?
Yes, Judge. And speaking of Mr. Cross, he was born in Boca, went to school in Boca Raton. Judge, my understanding is he works in Seaway Marine. He's a dockhand. He makes approximately $12 an hour. Fortunately, at this time, there's, from what he's telling me, there's no one he can contact to help post his bond. My understanding, Judge, and he was trying to tell me about the facts of the case. I advise him that he'll have his opportunity at trial. My understanding, reviewing the PC affidavit, there was 3 gentlemen involved. There was one that was the alleged victim. The touching seemed minor in the grand scheme of things, Judge. I'd ask you to consider setting a bond in the neighborhood of $500.
Here's my concern. The arresting affidavit indicates that he lives permanently in New York in Queens, Far Rockaway. And so he has no ties to this community. Being born here is one thing, living somewhere else is another. So why would they say he lives in Far Rockaway?
No. He lives in New York. He's here.
No, I heard he's working here, and now all of a sudden he's not working here. He's just living here.
He was born and raised in Boca.
You know, that's great, being born and raised, but I don't see any ties to the community. He moved away. He lives in Far Rockaway. That's right on the water, real pretty part of Long Island, although people don't realize it's Long Island. It's still on the island. It's Queens, right?
I believe the marine is called Seaway Marine.
Okay, but the Seaway Marine is in Far Rockaway, right? You're in New Jersey. You're working in New York, right?
Yes, sir.
You're here on vacation?
Yes, sir. I have a hotel in Deerfield Beach.
What hotel you staying at?
The Deerfield Beach Motel.
Uh-huh.
Was actually where this altercation.
Okay, and how long, now, you know, how do I know you're not going to skip bond and never come back to Florida?
Your Honor, I haven't been in trouble in a long time.
That's not what I asked you. Listen to my question. I didn't ask you if you've been in trouble in a while. I asked you, how do I know? Don't interrupt me. How do I know you're not going to skip bond and stay up in New York? What assurances can you give me that you're going to come back to court?
I have $1,000 in my possession, and I'll give that to you. And I want to get my money back. And I know that this case that I can. There's nothing that I would run from.
Yeah, well, you can't give me your money, sir. I appreciate that. You're not allowed to give me any money. I understand. I know, as a bond. Now, do you have family still in Boca?
Yeah, my foster mother lives on Southwest 18th Street.
Does she know where you are right now?
Absolutely not.
Well, then that shows me that there's no ties to this community anymore. Sir,
No, she knows I'm.
sir, if she doesn't know you're in jail and you're supposedly tight with this family, then you have no more ties here.
No, I haven't been to a phone since I've been arrested. I've been in holding cells. And,
Well, let me ask the question this way. Now, you've been in South Florida for how long since you got arrested? How long?
since
what?
the second, sir.
How many times have you seen your stepmother since the second?
Well, we went to Dubliner and had dinner,
Uh-huh.
and I've only been here a couple days.
So you've
Went to
seen
Dubliner.
you've seen her once.
Yes.
Okay.
I've been hanging out at the beach, just
Hanging out at the
enjoying
beach. All right.
seeing old friends.
Obviously, none of your friends are here today.
Your Honor,
I'm concerned. I'm concerned that you're not going to come back. What state's not being unreasonable at $5,000?
Sir,
$5,000, Judge.
What's that?
It's a third-degree felony. It's a third-degree felony, Judge.
Maybe, but he has no ties to the community. He's accused, if the facts are true, and I take them as true for the purpose of the probable cause hearing, he committed a battery on a person over the age of 65 years old. All right? What do you, and hold on, stop. Let me ask you another question. What's your job? You work at a marina, right?
yes, sir.
What do you get paid?
$12 an hour.
So a guy comes to Florida with $1,000 in his pocket and he's only making $12 an hour. I mean, it doesn't make sense.
Well,
Bond-
that's my first vacation in 5 years, Your Honor, and I you know.
And you have no credit cards and you just took cash out. How you paying for the hotel?
Cash. It was $505 for the week. It was very expensive.
Not for the
Yeah,
beach, not for Deerfield Beach, $505. That's a deal for Deerfield Beach for the week. There's some places on Deerfield Beach you can't stay for the night at $505. All right. Bond is set at $2,500. No contact with the victim. Good luck to you, young man.
Would you sign the photo orders, Will? well, Judge.
If you require one, any objection from the state?
No, Judge.
Granted.
Would
Thank
you want a
very
photo
much.
order?
He said, yeah, photo order. No problem. We can take care of that. Thank you. Gary Hall, please.
Mr. Hall's here present.
All right, court finds probable cause. 1 count aggravated battery. Let me hear from the state.
Does pretrial, he's not on my list, does pretrial have any criminal history for Mr. Hall?
I don't have an address for him.
He's a juvenile.
What's that?
All juvenile ties, Your Honor.
All juveniles, but he's
20.
20.
That being
He'll be
said, Your Honor,
21.
based on the level of violence alleged in this affidavit, the state would be requesting a $15,000 bond and no victim contact.
This gentleman's accused of hitting a victim in the head with a brick. What's the response of the defense? Either one of you gentlemen.
Judge, in speaking to Mr. Hall, he's 20 years old. He's been living here his whole entire life. He was working at Publix. He lost his job due to various reasons, so at this time he's unemployed.
What was the reason he lost his job?
He explained to him what you told me.
What happened?
I had left the job because they were giving me less days because they were hiring more people.
So you quit? You quit because they gave you less days, so you go from, say, 5 days, they cut you back to 3 days, and so you quit? So now you have no days?
No, I'm trying to get
That
another
doesn't make
job.
sense. Yeah, I hear you, but no one quits a job if you don't have another job, so they cut you back. Yeah, that's not nice to get cut back, but why would you quit the job to get no days?
I mean, I didn't want to be homeless intentionally, sir.
Sir, you quit a job. They cut your hours, okay, stuff happens, but to walk out after they cut your hours without anything else? You have family in the area, Mr. Hall?
Probably just my auntie.
Your auntie, okay. Did you go to Deerfield High? Did you
I
go to,
graduated.
you graduated Deerfield Beach High? Okay.
No, not different.
Where?
Mavericks.
Maverick, okay. You don't own a house, you own a car?
No.
So, and you're living on the street?
Yeah.
Well, so how's he
I
gonna,
could live at my auntie's house. I just don't want to burden her with me not having a job as being a man until I find me a job personally.
does your auntie know you're in jail right now?
I don't think so.
Well, if you didn't,
This happened on yesterday.
all right. What kind of bond are you looking at, defense?
Judge, I mean, at this point financially, he can't really afford anything. I know he told me, I asked him if he could contact his aunt. He said his aunt might be willing to have him reside with her.
Okay, well, that's
not
a
to put
start.
up any sort of monetary bond.
But he's accused of taking a brick and
I know.
smashing a guy's head with it. $10,000 bond, no contact. Thank you.
Judge, also, would you sign an order allowing us to photograph Mr. Hall's injuries?
Any objection by the state?
No, Judge.
Granted.
Thank
Thank you. Good luck, sir. Tavon Johnson.
Mr. Johnson's here approaching, Judge.
Good morning, or good afternoon, Mr. Johnson. Court finds probable cause, possession of cannabis over 20 grams, and possession of drug paraphernalia. Bond is set at 1,000 on count 1 and 100 on count 2. And I wish you well, sir. Yes, sir.
Mother already contacted the
Johnson,
bond.
here's the
What's that?
gentleman that's,
His mother already contacted the bond.
Oh, his mom is bonding him out, according to
okay.
pretrial release.
Bonding you out, right? When
Probably,
they contact her, so she's already.
probably within the next day, maybe even sooner, okay? Good luck
Yes,
to
sir.
you. Thank you, sir.
Thank you.
You're welcome. John Austin.
Mr. Austin.
Hi, Mr. Austin. Two matters before the court this afternoon. First is a probable cause possession of cocaine. Bond is $1,000, and the second is an outstanding warrant, no bond hold on a felony, and I wish you well, sir. Leonardo Floritanis. Thank you. Good afternoon, sir. Court,
Good afternoon.
1 count kidnap, committing, or facilitating the commission of a felony. State.
Your Honor, and I showed to Mr. Reading, I provided to the court Judge Siegel's original findings at his original first appearance and the information that the state filed. As you can see, it's essentially, it came through as a kidnapping to facilitate inflicting bodily harm. We filed it as a different type of kidnapping, same level of kidnapping. We also filed the armed burglary that he's being held no bond on. So we just asked the court to reimpose the $500,000 bond that Judge Siegel kept in place at his original first appearance.
Response, please.
Judge, he's being held no bond. He's going to have to go in front of Judge Siegel, and at that point, those issues can be addressed.
So you want me not to do anything now?
Well, I think you have to
Has
set a
something
bond.
has
You have
be
to set a
said.
bond on count
Right,
2.
so what are you suggesting?
Well, he has a no bond hold. I'd ask for a $10,000 bond, Judge. He's being held no bond anyway, so.
If the court's going to consider, then I'd ask to print out the report, but the reason I only printed out those two forms, Your Honor, is so you could see, it's really a technicality that's a change of charge. It really frankly shouldn't even be up for review. He was arrested for kidnapping on the arrest warrant, and that's what we filed.
Right. A bond is set at $250,000. Thank you. Next, please, Robinson Charles.
He's in regular court, Judge.
He's where?
He's in court.
Okay, we'll reset.
Well, Your Honor, if I may, he was actually arraigned this morning.
Okay.
In this case before Judge Usan.
Okay.
The bond was originally set at $7,500, and frankly, I don't know that this court, even whether it's today, tomorrow, or any other day, has jurisdiction once to set a bond once he's been arraigned by his judge.
So he's already been arraigned and the judge has set bond?
I don't know if the bond was even addressed. I'm just asking that the bond be kept where it was at
Well,
the
if
time.
I don't have jurisdiction to change a bond, then I don't have jurisdiction to say that the bond should be kept. If the bond has already been set, then the bond has been set.
Well, it was set Your Honor, it was set on a burglary dwelling. We filed a burglary
Who's his
dwelling.
attorney?
I believe I'll check, but I believe it's a public defender. Yes, he has the public defender, Your Honor, and the only reason I was asking to have the bond reset is so that he's in the same position he was before he saw Judge Usan for his arraignment.
But if Judge Usan, who's the division judge who's hearing this case, has already set a bond, who am I to upset?
It's not that he set a bond, Your Honor. He had a first appearance, and a bond was set at the first appearance.
So then why am I gonna touch this?
Your Honor, what I'm asking is that he has a bond as opposed to being held no bond.
Okay,
And all
so
I'm asking,
now I understand. So you're saying that it's supposed to be $7,500?
that's where it was set at his first appearance.
And what's the response? Brian,
I'm looking at it right now, Judge.
take your time. Mr. Lewis, I should have gone, who are you waiting on? Oh, I'm sorry. All right. I apologize. Make sure Mr. Morris is next.
From what I can see, Judge, it looks as though there's no update as to what happened this morning before Judge Usan. I see he has a criminal mischief on his other case, and there are other issues that come into play as well. Judge, I'd ask for a $5,000 bond. Let Judge Usan resolve this matter. It's coming in front of him no matter what. So,
And Your Honor, respectfully, I don't know that the court can change the bond from where it was. It's really I think
I
those
get
decisions
it.
have
So
to
if the
be-
court can't change it, why was it here in the first place?
Because that's, Your Honor, it's a procedural issue. I've spoken with Judge Pohl about changing this, and it's being worked on. Frankly, these cases shouldn't come through here.
I'm gonna set it at $7,500, and obviously the division judge has the discretion to do what, in this case, he thinks is right. All right, my apologies, Mr. Lewis. Neil Morris,
Conti, Your Honor.
thank you.
Good afternoon, Your Honor.
Good afternoon. Now, you have Mr. Lewis here, so unless he directs you to say something, don't say anything, okay?
Yes, sir. Yes, sir.
Can you see him on the video screen? You able to see him?
Yes, sir.
Okay, good. All right, very good. State, you want to be heard?
Your Honor, just to advise you the procedural history of this case. When Mr. Morris was originally arrested in July, he was charged with robbery through firearm or deadly weapon. Judge Arlene Backman found proof evident or presumption great and ordered him to be held no bond. Since then, the state has filed a charge of robbery by sudden snatching with a firearm. It's a second-degree felony. He is entitled to a bond. So I provided both Mr. Lewis and Your Honor with a copy of the probable cause, the original probable cause affidavit.
Okay. Mr. Lewis, well, let me start with you then. The state, what do you believe a proper bond amount should be?
Your Honor, the state is going to be, based on the allegations and the strength of the evidence in the case, Your Honor, the state is going to be requesting a $50,000 bond, noting also the alleged use of a firearm, but noting also that when this offense occurred, Your Honor, Mr. Morris was out on bond for a battery, which since this arrest, Judge Pohl has actually revoked his bond on that case.
So he's in on a no bond hold.
He's got a no bond hold on a misdemeanor battery.
Which we're going to address with Judge Pohl now, especially that the charges have been downgraded.
Additionally, 2012 burglary of a conveyance with possession of alprazolam, 2009 assault and 3 counts of theft, Your Honor.
Okay. And the state's request is $50,000.
$50,000.
Let me hear from Mr. Lewis.
Judge, I'm requesting a $5,000 bond. When you read the probable cause affidavit, there's a situation where somebody was owed some money and they took somebody's cell phone because the brother didn't show up to pay the debt. So I don't think it's the kind of, there is no, obviously they did not believe that a firearm was used during the commission of the offense, or they would have charged it armed robbery. They didn't do that. So in light of these allegations, I think a $5,000 bond is more than sufficient.
Last time for the state.
Yes, Your Honor, just noting, under the information, it is alleged that there is a firearm in possession during the offense.
But they
It's
just didn't use it.
It has to do with how the taking occurred, Your Honor. In this case, it was by
Was the
some statute.
firearm taken as an incident to the arrest? See, as the state's position that although a firearm wasn't used, he had a firearm in his possession when this happened, but he didn't show it in any way?
Well, he did show it because it's noted in the report that, one moment, Your Honor.
It makes no sense. If he had a firearm that was displayed during the robbery, it would be charged
Page
armed
3,
robbery.
middle paragraph, a show-up was conducted, and he was positively identified as the person who displayed the firearm and took his phone from his possession.
And noting also, Your Honor, when when I made reference to the evidence before, what I was noting is when Mr. Morris and the other person in his vehicle were stopped, they did recover a firearm from the vehicle and the victim's phone.
$25,000 bond, thank you. No contact.
Thank you, Judge.
Thank you. Sorry about missing you, Mr. Lewis. I apologize. Rafael Kappa Mendez. Mr. Mendez, good morning.
Good morning.
All right. So you and I met July 4th.
Yes.
And here we go again. State, what are you looking for now? At the time, I set a bond at $5,000.
The state is I'm gonna ask Your Honor to reset that bond. The reason being, I reviewed the probable cause affidavit. And yes, while the charge was listed as burglary dwelling, it is clear from the reading of the probable cause affidavit that the facts is that it was a business. So I would imagine the court was aware of that when determining appropriate bond. Also noting, Your Honor, and I imagine this was also in the court's consideration, that it appears that Mr. Capa-Melendez does not reside in Florida and resides in Puerto Rico.
What do you think an appropriate bond is?
I think the bond you originally said was appropriate, Judge.
The $5,000 bond?
Yes.
All right, and the response, please?
Judge, he's not going to be able to make that bond. I'm going to ask the court to sign an order granting him access to his phone. He might be able to make contact with some people to help him bond out.
So he's been in custody now since I saw him July 4th. So he's been here 55 days, 60 days almost, a little bit less, right? Today's the
Yeah, it's
8th,
a
so
little
it's
over
30,
30.
33 days, all right. And he hasn't been able to make the $5,000 bond. I'm going to ask you a question, sir, and you don't have to answer it. So if I gave you access to your phone, you think you'd be able to call some relatives to help you out?
I will try to do that, sir.
I'm going to reduce the bond to $3,500. Thank you, gentlemen.
Thank you, Judge.
You're welcome. Good luck to you. Kavan Jordan.
Mr. Jordan's here, President May.
Thank you, Mr. Jordan. Good afternoon. Mr. Jordan, there's 2 counts. The court finds probable cause, possession of burglary tools with intent to use and grand theft auto. Bond is set at $1,000 on each count. I wish you well, sir. Thank you.
Judge, Mr. Jordan is requesting if Your Honor would consider pretrial release right now, he's having the help of his adopted mother help him go through the process of initiating getting disability. So right now
Okay.
he's not working, no money. If pretrial can verify his address, he lives in with his mother in Miramar. Would you release him on pretrial?
What's pretrial's position?
Now, our position is that we attempted to interview this defendant at 3 different occasions. He told us he was not interested.
Okay.
We asked him, so if the court wants to reset him for tomorrow or
Let's do this. I'll leave the bond at 1,000 each. If he wants to make himself available the next time pretrial release is there, great. If not, it's $1,000 on each.
Could it be pending verification then? So then they could get
No,
his
no, no,
information?
no. He's got to show that he really wants this interview. They're not going to start doing homework until he looks at them in the eye and says, it's time to get to work. All right? So that's what we're going to do. All right, thank you. I wish you well. Thank you. Cedric Gibson. Where's Mr. Gibson? Which jail?
Judge, Mr. Gibson is a medical reset.
Thank you. All right. Anything else from the clerks today?
We got one second look and 4 motions to release.
All right. So let me have the files. The first one is what, Navon Rand,
PC on that one?
correct?
Did you show the judge the PC on that one?
No fraud, Your Honor, he's approaching.
Thank you.
Come in. Stay right down there.
How you doing?
Not so well. Thanks for asking.
Sorry to hear that. What's the matter, sir? What's the matter?
I've got some mental issues, but I'm incarcerated, so
Okay.
I don't mean to be flippant. Your
No,
Honor.
you're not being flippant. It's a terrible place to be. There's a lot of better places to be. So you had a probable cause hearing already, correct? And you had a hearing already with the judge prior to coming back to see me. Is that right?
I saw somebody Sunday morning. I
Okay.
believe.
Your
I
Honor.
don't-
Yes. Yes, state.
Mr. Rand, he saw Judge Lerner Rand Sunday morning. The state's going to be requesting that all the release conditions be kept in place. I believe they're very reasonable. He has a total bond of $5,000. This involves a second DUI, that multi-car accident with breath readings at .250, .239. He was also ordered to, should he post his bond, pretrial release with a TAD monitor, a BARC evaluation, and no alcohol or intoxicants.
Okay. Any response?
He's in Judge Lerner Ren's courtroom now?
No, she was the judge.
She was
Sunday
the
morning.
magistrate
Oh,
judge
okay,
on Sunday.
okay.
Sir, I got to tell you, the state's telling me this is your second DUI, and the state's telling me that allegedly as a result of this, that you may have injured other people. I'm going to keep the bond where it is. Thank you very much.
That's it.
That's it, sir. Thank you. I wish you well.
Have they filed charges yet?
It's been a few days.
They have some more time to do what they need to do, sir. Okay? Do you have an attorney, or do you have an attorney?
I requested a public defender.
Okay, then if you file the affidavit, then one will be appointed to represent you. They represented you today as well, sir. I
I'll
wish you-
contact whoever representing you, Mr. Rand, to make sure they come up and see you as soon as possible, okay?
Thank you very much, sir.
I wish you well.
Thank you. You too.
Thank you. All
You
right.
done?
Yes, sir. Thank you. Jesse Mosley, please. What's that? Paul Ryan, okay.
It's a doubleheader.
And he's got yeah, you see, you remember what I used to call them, right? Mr.
I didn't, but
That's,
maybe it was in there subconsciously.
it must have been like, what are they, subliminal?
Yes.
Is that it? Subliminal. Okay.
Your Honor, we have not filed the information in either of Mr. Mosley's cases.
You have not?
We have not. He is entitled to ROR on these charges.
I'm looking at it. Mr. Mosley, if this is the only thing holding you back on both these cases, you're being released today. Thank you and good luck.
Thank you.
All right. Keyshawn Knight. He's a happy guy. All right, he's happy. He's doing the happy dance. Yeah, that's good. I'm happy you're happy. All right. Where's Keyshawn Knight?
North Road, Your Honor.
Thank you very much. Mr. Knight, how are you? State, what's your position here?
Your Honor, the state has filed an information.
The state has filed an information? Have you seen the information, defense?
Here,
I have not,
I can
but
print a copy of.
Okay.
what charges were filed?
Well, they're both the same charge, each counts.
Delivery of
And the two counts
cocaine within
filed?
1,000
I think
feet.
maybe only one was, so the jail, when the jail receives the paperwork, they're gonna take care of that.
All right, sir, so the charges have been filed and the bonds have been set, and I wish you well. Next case is Ronald Groninger.
Conti, Your Honor.
Thank you. Hi, sir. Good afternoon.
State has not yet filed an information. Mr. Groninger is entitled to release on these charges.
Sir, if there's nothing else holding you back, you're released on your own.
Thank you very much.
You have a good day. Thank
I
you.
appreciate it very much.
All right. Is there anything else from the clerks? Pre-trial release? State?
Sir.
Defense?
No, sir.
I have to sign an order, though. Yes, I have one order to sign. All right? Other than that, so same time tomorrow. I'll be in a little after 7. We'll start at 8:30, and we'll do it all over again. It was a pleasure today, everybody. Thank you for your collegiality and your professionalism and your nice sense of humors. I appreciate it, how well you all work together. Thanks for letting me visit today. All right.
Welcome back anytime.
I appreciate it. I appreciate it. Always have a box seat. Thank you so much.